What I'd like to do is try to give you a little bit of a sense of how the class would actually run. And my primary course is constitutional law. That's the course that I spend the most time on, that I write my papers, my scholarship is on constitutional law. So I thought I would take a minute here just to give you a brief introduction. And instead of doing an overview of the course, what I'm going to do is go in depth on an early lesson so you get a sense of what class will actually feel like. All right, so constitutional law, there are two major topics that are covered in constitutional law. The powers of the government, the structure of our government. So the judicial branch, the legislative branch, the executive, the powers of each branch, checks and balances. We're looking at the structure of how the US government works. The other big topic is individual rights. So a right to privacy, freedom of speech, freedom of religion. That's the second half of the course. What I'd like to focus on right now is that very first topic of judicial power, the power of the courts in our system in the United States. And one topic that we would cover very early on is called the case or controversy requirement. And so I would start out with a slide like this, where I try to give you the big picture, and I give you an idea of the general rule we're looking at. So our big picture on this little lesson I'm going to try to cover in 10 minutes is that federal courts, there are state courts and federal courts in the US. The federal courts only decide cases or controversies. What that means is they cannot render advisory opinions to the political branches. So when Congress passes a law, the court will not advise as to whether or not that's constitutional. A congressman can't go to the Supreme Court and say, hey, if we draft this law this way, would that be constitutional? They're not allowed to do that in our system. Instead, Congress passes the law, the executive then either signs or vetoes the law, and then litigants, private parties, can bring lawsuits challenging it in the context of an actual case. The policy behind this, it's based on separation of powers. The idea is that if the court could just advise the president, the court could just advise Congress on what the Constitution says and what laws should be passed, that would give too much power to the court. Then the court would act as sort of, in charge of the president and Congress, and we don't want that. Right? We want three equal and independent branches. And so we can't have the courts telling the other branches what to do in the abstract. It has to be within the context of a case with adverse litigants. This comes from the Constitution itself, right? When you look at the text of the Constitution, it says that the judicial power goes to the Supreme Court. As you would imagine, right? It's a court, it has judicial power. Well, what is that judicial power? Constitution says it extends to cases and controversies. Court does not have the power to otherwise advise the political branches. So they can decide cases, it extends to cases affecting ambassadors, cases of admiralty, controversies, etc. So the Constitution itself limits judicial power to cases or controversies. So that's our big picture concept. What types of disputes will the court hear? Well, it has to be an actual case or controversy. The way this gets translated into the law is through these four doctrines. We have the standing doctrine, ripeness, mootness, and political question doctrine. And in class, we would spend a few hours going through each of these in detail. I just gave you the big picture. Now let's get started on standing. I want to talk just briefly about this first and most important requirement here. This asks whether the case was brought by the proper parties. We have to have the right plaintiff suing the right defendant for it to be a case or controversy. We don't just look at the case or controversy doctrine in the abstract. It's translated into the law through these legal doctrines. So what we would say here, to have a case or controversy, you have to have a plaintiff who has standing. Standing means a plaintiff has standing if this test is met. This is the rule. right? So this is the rule of law that I would want you to memorize for all this. This is the key point that you really need to know, would be this slide. A plaintiff must allege an injury that is, in fact, it is concrete and particularized, actual or imminent, not abstract or conjectural. So they need an injury in fact, a particular type of injury. They need causation. Number two, the injury has to be caused by the defendant, has to be fairly traceable to the defendant's allegedly illegal conduct. That just means the injury has to be caused by the defendant. And three, likely to be redressed by the requested relief. So we have to have, the plaintiff has to have an injury. It has to be caused by the defendant, and the court has to be able to provide a remedy. They have to be able to redress that injury. They have to be able to provide a remedy. So this is our basic standing rule. We're looking for a plaintiff who meets these requirements, suing a defendant who caused the injury. Then, so that's our basic rule of law, right? I said in every lesson, that's what I'm going to do. I'm going to set up the big picture. Might go into a little bit more detail. I'm doing this in an abbreviated way for this, but I would set up the big picture, give you the concrete rule, the rule of law you need to know, and then we go and look at it through some cases and hypotheticals. Excuse me. So I'll just do this very briefly. In class, we would spend more time on it. But I would give you the facts of the case. I would talk through the case for you, try to explain what's going on. So this case is Luan versus Defenders of Wildlife. And I'll just summarize this at a high level for you. In Luan, we have a number of environmental groups suing the federal government because the federal government is not doing an environmental review when they're funding projects, development projects overseas. So essentially, these environmental groups are worried that the US government is funding projects in other countries that could kill endangered animals, that these projects would be bad for the environment. So they sue, saying that that the US government is not following the Endangered Species Act that protects endangered animals. Again, I would go into more depth on this in class, just for time purposes. That's about all we need to know. These environmental groups are suing the government, saying that they're not following the law, and that could lead to the development of projects that would kill endangered animals. The court goes through our standing test and finds no standing. The plaintiff there's not a real case or controversy here because these are not the right plaintiffs to bring the suit. There's no standing. The court says, first, there's no injury. There's no injury because these environmental groups are not really injured in a concrete and particularized way. They're not injured in a special way. If the US government funds a project like the building of a dam or I don't know, some sort of development project, flood control on a river, well, that doesn't hurt these particular plaintiffs in any special way. Sure, they love animals, they're environmental groups, but they're not injured in a direct way that is special to them. The court says an injury that is abstract, like, they care about the environment or they study endangered animals and they're concerned about them, that's not enough to give you a stake in the case. That's the idea here, is that we want a plaintiff who is actually injured by the law, challenging the law, so that they have an actual stake in the case. And we have a plaintiff who is adverse to the defendant and they're fighting it out and presenting the strongest arguments on both sides. Here, the court says, well, these environmental agencies or groups, they're not injured in any sort of particularized individual way. They're just upset that these animals could be killed. Next, looking at, there's all these other injuries that the court goes through. I think for timing purposes, I'll skip over that. The court then goes on to our next two elements and says, even if you could show there was an injury, there's no way to show redressability. There's nothing the court could do about it because even if the US government stops funding these development projects, say in, building a dam in Africa or something like that, even if the US government stops its involvement, those projects might continue overseas from the foreign government, right? Even if the US government pulls out funding, those animals might die anyway. So the court says there's nothing the court can really do about this that would affect the plaintiff. So this plaintiff is not the right plaintiff to bring the lawsuit. So I mean, I'll just summarize from here on out. Again, we first looked at the big picture, the policy. We look at where this comes from in the text. I then flag, roadmap the doctrines that we're going to use, give you the rule of law. We go through a case. I know I did that very quickly, but you get a sort of sense of I'll be going through the case in a specific way, bringing out the main facts, the application, trying to explain it in as much detail as I can. Then we would do hypotheticals. I would have slides like this on the screen, and I would ask you to type into the comment box, if you think it's A or B. And we would go through a number of these, and we would talk through them. We would talk through them to make sure that everybody's getting the right answer. Then we go on to the next doctrine. So then we go on and do ripeness, then we do mootness, political question doctrine, and then I would have an essay at the end that we could all work through again, and I could give you feedback on. So I hope that gives you a sense of what the program is like, what these classes are actually like, and I would be happy to take any questions you have about the program. Either here, or if you would like to email me, I'm happy to take your questions by email as well. Thank you.